Well, gentlemen, we are going to see the applications cognizable by revenue officers. When we talk of the Punjab Tenancy Act, we find that there are the courts which are known as revenue courts, and at the same time there are revenue officers. So their work is distributed. The distribution has been given in the Punjab Tenancy Act. Under Section 75 of the Punjab Tenancy Act, there shall be the same classes of revenue officers under this Act as such the Punjab Land Revenue Act 1967. Jurisdiction of revenue officer is the same. Collector and Board of Revenue have the same meaning. Meaning, it shows that whatsoever the meanings are found in the Punjab Tenancy Act, those meanings are found in the Land Revenue Act. So, when we are studying the land laws, we find that there are revenue courts and there are revenue officers. Revenue courts take the cognizance in the suits, while the revenue officers take the seizure on the applications. Then when there is an application, then the officer exercises the power as the revenue officer. When there is a suit, then that revenue officer is automatically converted into revenue court. So there is a distinction between suit and the application. Suit starts from the presentation of plaint. And what are the cases wherein the suit is instituted has been given in the Punjab Tenancy Act. And similarly, what are the cases when the applications are presented, the same have been enumerated in Section 76 of the Punjab Tenancy Act. Section 23 of the if we find that this section has been divided into groups. When we go through the first group, we find Section 27 for adjustment of rent expressed in terms of the land revenue. Then this question arises, then there shall be a revenue officer and there shall be an application which shall be presented before the revenue officer. If there is a suit, then he will exercise the powers as a court. The procedure of the suit is altogether different from the procedure of applications. Applications are usually and normally summary in nature, while the suit is to be regularly proceeded in accordance with law. It is well settled law that the suit starts from the presentation of plaint. But when the suit starts from the presentation of plaint, the revenue court takes the jurisdiction. But when an application is moved and that is not the suit, that is summary in nature, then that is called the application. Application is simple words, is a prayer that such and such thing is required and that may be given. So in that situation, what will happen? The revenue officer shall issue a notice to the concerned party, hear the parties, and then decide it. But if he wants that there should be some inquiry into the matter, he may refer the matter to his subordinate to do the needful. So in that situation, the application is disposed of. So when there is a suit, the procedure is altogether different. But when there is an application, the procedure is different. A tenant is ejected when a decree for arrears was passed. How the decree is passed? The decree is passed in the suit for ejectment. But when the decree is passed, then how he will be ejected? Then section 43 says that he shall be ejected through an application. So tenant to eject when a decree for arrears has been passed is through an application. A tenant for year to year may be ejected on application under section 45 of the Punjab Tenancy Act. What will happen when there is a tenant from year to year? An application shall be moved to the revenue officer under section 45. What will he do? He shall issue a notice to the tenant. And if a notice of ejectment is not contested, then the tenant shall be ejected forthwith. And there may be a situation when a tenant demands compensation. So the demand of compensation by the tenant shall also be decided in the same application. So the procedure will be that an application under section 45 shall be moved for the ejectment of tenant on the basis of a decree of arrears of land revenue. And the revenue officer shall issue a notice to the tenant to show cause why he should not be ejected. But if he does not contest the same and makes that he should be make amends for the losses or compensation should be given to him, then in that situation he will decide the application. So the applications are decided by the revenue officer. Now, if the question of compensation has been decided, then the time will come that as to how and when the compensation is to be paid. So in this situation, the revenue officer shall exercise his powers and decide that ejectment should be postponed till the compensation is paid. And if the landlord pays the compensation, then he shall be ejected. And there are certain circumstances when the rent is to be deposited by the tenant. If the landlord requires that a rent should be deposited, he may apply. And if the tenant wants to get it deposited, even then he can apply. So in both the situations, for deposit of rent under section 31, an application shall be moved to the revenue officer. There come certain situations when the tenant finds that he is not in a position to further continue the tenancy and he wants to leave the tenancy, he wants to abandon the tenancy, he wants to relinquish the tenancy, then notice of relinquishment by tenant shall be given under section 36. The procedure is that he shall apply, he shall make an application to the revenue officer. The revenue officer shall serve a notice of relinquishment by the tenant, and a tenant shall be allowed to vacate the premises. If the tenant is holding the property for a fixed term, he may relinquish it without notice at the end of that term, meaning thereby that if the tenancy is without date, then he is bound to give the notice. But if the tenancy is for a fixed time, then on the expiry of the fixed time, he may relinquish the tenancy without notice, and no application is required for this purpose. But in all other cases, he may relinquish after giving notice before 15th of January. The law fixes the time of serving of the notice for relinquishment, that is 15th of January. So the relinquishment is applicable when there is a fixed time and he wants to relinquish before time. And if there is no fixation of time, then before 15th of January, he shall make an application for the relinquishment. Then suppose a tenant is in possession of 10 acres of land. He wants to relinquish 5 acres from it. He cannot relinquish it without consent of the landlord. If a tenant wants to relinquish the tenancy partially, he wants to hand over a part of the property to the landlord, he cannot do so without permission of the landlord, without consent of the landlord. But if he wants to relinquish part, then he shall also apply to the revenue officer. He shall serve a notice on the landlord, will hear the parties, and if there are certain circumstances wherein it is necessary the relinquishment should be made, then he may pass an order. But generally, without consent of a landlord, partial relinquishment cannot be allowed. So Section 77 deals with the revenue codes, while Section 76 deals with the revenue officers. In this act, a revenue officer is the same person who is the revenue code, but the determination whether or not he is a court or whether or not he is a revenue officer is determined by the action which is going to be taken. If the action is taken to proceed with the suit, then he is a revenue court. But when the action is taken to proceed with an application, then he shall be deemed to be the revenue officer. It should be kept in mind that these classes are also available in the Land Revenue Act 1967. So the main point which requires the consideration is that when a party is going to move the authorities, what relief he intends to get. If the relief relates to the matter enumerated in Section 76, he shall move an application to the revenue officer. But when he finds that his relief is available under Section 77, then he shall move the court by instituting a suit, and the suit starts from the presentation of plaint. So we have to keep in mind the distinction between plaint and application. Thank you.